No.
Okay.
Feel in the matter of employment of professional foster carers and certification officer and others.
Yes, Mr. President, sorry to keep you waiting.
Not at all, my lord. Good morning. I'm going to start by just setting out who's appearing for who and identifying where in the court we are, so you can
Yes.
bases. We will move around a little as we come to address your lordships.
Yes, I'm a bit puzzled why we clearly want it to be live streamed, but there are bigger live streaming courts, and I'm not quite sure why we've been put in this one, but you've all fitted yourselves in.
We are dotted around, yes.
Yes, well, I'm sorry about that, but
Not a problem.
nobody, I don't want to mean this rudely to solicitors, they're all obviously following on, but nobody essential has been unable to arrive up there, because if they have, we would try and get you another court tomorrow, but
I think we're all fine.
you're all fine. Okay.
So in terms of representation, my lords, the appellant, represented by myself, David Stevenson and Rachel Barrett, the respondent, that's the certification officer, represented today by Ben Cooper and Jane Russell. We have our interveners. First intervener, IWGB, represented by Lord Hendy QC, Catherine Newton QC, and Madeline Stanley, who's not in court today. The second intervener, Secretary of State for Education, who's represented by Ben Collins and Robert Rosso.
In the case of Miss Stanley, just thinking ahead to the judgment, we should recruit. She is appearing. She's just,
Please,
but
absolutely.
she's attending remotely.
As
Fine.
with David Stevenson,
Yeah.
For the appellant as well. Thank you for clarifying that. The third intervener, Local Government Association. The Local Government Association is not taking active part in this hearing.
Yes. Now, can I just ask one question about this? I meant to ask my colleagues, but we were too busy discussing the substance. I was not able to find, but it was only too late that I discovered I was unable to find any written submissions from the LGA.
They've not put them in.
Oh, right.
They're content to rely on submissions made by certification officer and the Secretary of State for Education.
So, in fact, in what sense are they parties if they're not making any submissions?
Well,
not parties is the wrong word. In what sense are they intervening?
Well,
It's not for you to say, but
They put in witness statements, didn't
they played an active part below in the EAT.
Yeah.
oh, that's another matter. Yes.
And they were given permission to intervene, and I'm sure should this matter go any further, they would want to consider whether they would play any more an active role than they have for this. But I think they thought in terms of the use of court time and so on, they were content.
No, well,
there
that's
to-
very responsible of them. But I just wanted to make sure. I would have thought that their formal position is that they have not, in fact, intervened, because if they aren't making either written or oral submissions in this court. Anyway, This is a footnote. I just
It is.
don't want to do them again.
Did not appear and were not represented.
Yes.
I'm
you.
sure they would appreciate that, my lord. We can double check with them overnight and get back to you about.
Well, that would be that. I don't see why you should, but I should have to. But that will be useful.
And of course, I must mention our fourth intervener, the European Children's Rights Unit, or ECRU, represented by Mr. Burton, to my left. May I next check the bundles that your lordship should have before you? We've got volume 1, the core bundle, which you'll have either in hard copy or e-bundle form. And when I refer to that, I will call it C123, or C for core bundle. Then we have a supplemental bundle, also I believe in hard copy or e-bundle form, however you wish to use it. That's also called volume 2, but I'll be calling it S123 for supplemental. And then we have an authorities bundle, which is rather longer, and that likewise appears in both hard and soft copy. And I'll be saying A for references to that. All the bundles have hyperlinked indexes if you're using e-copies.
Well, I think you can see none of us are, so don't worry about any of that.
About
Though
that.
I have to say it was useful in pre-reading. I didn't at that point have the hard copy authority, so it hasn't been wasted giving it to us.
Right,
but in court, none of us are using e-versions.
And we handed up to the court yesterday copies of all the skeleton arguments with authorities referenced
Yes.
in them. I do hope those reached your lordship at some point.
They did, but foolishly I have managed, I think, to leave them in my room. I might ask the associate, could you just send an email to my clerk asking her to come along?
My lord, whenever I take you to an authority, I'll be clarifying the exact page in any event. So
Yes, it's only
there's no
that I don't.
disadvantage.
It's only that I don't actually have
We've got a spare copy here, my lord.
of the skeletons.
Yes.
Well, I think I'd rather have my own, but thank you. If they don't arrive, I will ask for them. But I've marked them up.
Apologies for butting in, but just while we're sorting out those copies, the Secretary of State's skeleton, the updated version that was circulated yesterday, had one or two small errors in it, so we've tidied it up. It wasn't circulated yesterday, but we've got hard copies here today. It's useful for those to be provided. I don't want to cause more confusion than we already have with documents. So we're in the course
The skeletons have been a nightmare to work out which we're supposed to be working on. Rather oddly, Miss Krasnow, your skeleton still, your formal skeleton, is about a year old, but
Well, our amended skeleton is dated the 6th of December, but we put in a reply
yes,
on
well that
the
I do know.
30th of September and indicated that those two stand
To be read
together,
together. All right, I was just teasing you.
albeit the reply, for fullness and completeness, cross-refers to submissions by the respondents and the Secretary of State.
Yes. I'm afraid I ought to be on top of this. We have been rather coy, certainly in the early days, about handing up hard copies in open court. I think if you could make them available, we'll have them collected later. We'll manage with the versions we've got. Thank
Mr.
you.
Collins may have his sanitising spray behind him, I know not. But
Well, I think it's important that we don't do anything which suggests we are not taking these precautions seriously. So I think we'll have them given to us later.
a final point of administration, my lords. Because our solicitors can't be here in court today, some of our juniors are communicating with them by messaging rather than being able to take instructions where necessary.
Quite understood, and if that makes things a bit clunky occasionally, we'll understand.
That's very kind. We just wanted to say, if you see people checking something on their phones, I hope it's not Christmas shopping, but rather taking instructions directly. But of course, our phones are all on silent.
No, that's all understood, thank you.
So, a few introductory comments, and then I will set out how we're signposting the different parts of the argument and who's dealing with what.
Yes, that would be helpful.
Appellant's side. My lords, no doubt you'll be aware that this appeal concerns an application for listing made by the NUPFC back in January 2017. The certification officer rejected that application in July of 2017. The rejection was appealed to the EAT pursuant to Section 9 of the 1992 Tulka Act. The EAT rejected that appeal in July of last year, and the union appealed to the Court of Appeal, permission having been granted by my Lord Justice Underhill on the 22nd of January of this year. Now, the appeal involves a number of discrete issues. What I should emphasise that for today, the appellant has decided, given there is binding Court of Appeal authority on the issue of do foster carers work under contracts, that we are not making submissions on whether the EAT erred in law in holding that they do not, but rather we reserve that argument for a later stage if necessary. And just for your Lordship's reference, that is clarified in our amended skeleton argument at page 48 of the core bundle.
Yes. So we won't be hearing any argument about that.
Nothing at all, my Lord.
Can I just mention, in case, no idea whether it will go further, that's not up to us, but I'm sure it hasn't escaped anyone's thoughts, but I've not seen any reference to it. There's obviously been focus on Gillam, on the question of whether someone is working under a contract. But there is a line of authorities about general practitioners, which if it does go any further, I think would also need to be borne in mind.
There's an awful lot of law, which is another reason why we thought, not in the interest of justice, to take up this court's time with that issue, and particularly bearing in mind the President of the EAT did give a full judgment on those issues.
No, we understand why you've taken that course.
So who will deal with what today on the appellant side? I'm going to start with the first part of the Article 11 argument, that which is Article 11 engaged by foster carers working in an employment relationship? I'm then going to cover in very headline terms whether there was an interference with Article 11 and whether such an interference was justified.
Hang on 1 second.
Sorry.
So you're going to deal summarily only with interference and justification?
That's right.
Yeah.
Lord Hendy will cover the Article 11 arguments in greater depth.
Well, those Article 11 arguments, he's not going to deal with those Article 11 engaged, is that right?
He's not going to deal with employment relationship.
Yeah, okay.
He will cover, I believe, other elements of the engagement argument, but the bulk of the time will be on interference and justification.
Yes.
I'm then going to focus on the Article 14 issues of other status, analogous situation, and justification, as well as reading down under Section 3. That will take me up to about 3 hours, perhaps a little less. Lord Hendy will be approximately 2 hours on his Article 11 submissions, and then Mr. Burton will address you on how the EAT's acceptance of the respondent's justification defence is undermined by its approach to the interests of children. So that timetable will take up the bulk of our 6-hour slot, we believe.
Yes. Perhaps I can just say about timing that I think the original estimate given by the court was less than 3 days, but there was a good deal of pressure from the parties to extend it to 3 days. And once that had been done, then my Lord divided up those 3 days in the allocation to which you've referred. I think it's the view of all three of us that that's a pretty generous allocation, and I do not think you should feel obliged to take up 6 hours. These are some of them difficult points, but they're fairly focused. There's a lot of authority here, but not all of it is stuff to which I think we're going to need to be taken. So we would be frankly surprised and a little disappointed if we were here at 4 o'clock on Thursday.
It seems unlikely from where I see it that we'll go past Thursday lunchtime in any event.
Your amended skeleton argument, page 1, line 1, says rather encouragingly that the time estimate is 2 days.
We think it is important here that you hear from, in particular, the fourth intervener, ECRU, who has the specialist background to make those points on best interests of the child, which are very important to this appeal.
I'll just flag this up. I myself haven't quite understood under which ground of appeal they arise.
They arise under justification tests for both Article 11 and Article 11 read with Article 14.
But is it a ground of appeal that proper attention was not paid to the obligations under the Rights of the Child Convention?
My Lord, page 39 of the core bundle sets out our grounds of appeal. And little e on that page includes at the very end of that.
Just one moment. I have left behind a pile of newspapers which include my son's skeletons. I hope they're in my room. Why not bring those? They're definitely not in my room, is that right? And then hooked in the bag. It looks. It looks as though I not only left them in my room, but left them at home, which is shameful. But we will cope. If I need copies of, I've got your skeleton without the references because that's in the bundle.
Yeah.
So I think it's not going to be a serious problem.
I mean, we have them ready and waiting.
Thank you. Let's cross that bridge if we come to it. I'm so sorry. You were just showing us some.
Core bundle, page 39 to 40, a paragraph little e includes within it.
Yes, I see. You're going to refer us to the second sentence. These conclusions not open to the AT as the evidence did not include a lawfully compliant, balanced assessment of the best interest of the affected children. Yeah. Okay. Thank you. That answers my question.
My Lord, I have no doubt we will be as concise as we possibly can be,
Thank
and we may well take less than the time allotted. So unless there are any other queries from the bench or comments from my learner friends about timetabling or preliminaries, I will turn to the legal arguments. I'd like to start with us going to Article 2 of Tulka. That deals with the list of trade unions. And in the authorities bundle, Section 2 is at page 37. We see that Section 2, subsection 1 says...
I'm so sorry. Where are we?
We're in the authorities bundle,
Tab 2, page 37.
page 37.
But that's para 2 of Schedule A1.
I believe you've had an insert. I'm told you've had an insert to slot that in.
I was presented with a 300-page printout this morning of the 1992 Act with sidelining and so forth, with pagination beginning page 36.
And is page 37 section 2?
Page 37 is section 2.
So is that instead of... We'll have 2 page 37s, will we?
I'm not sure what my lord's page 37 is, but... My lord, I'm so sorry I didn't realise this had happened before, but I think the inset that my Lord Justice Bean has got is to be inserted in place of your existing...
Yes, I see. Well, I'm afraid it hasn't reached me. Don't worry, these things happen in cases. Obviously, a lot of trouble has gone into this bundle, but it is a shame that this...
Could you look at all page 153, I'm usefully told? You may have section 2 on that page. Just for these
We do. So, out of curiosity, why was it then thought necessary?
I think it was about the way that...
I won't ask.
There's no need for you to hear the detail of that. It's rather...
No, it's my fault. We have it. That's the important
Excellent.
thing. Yeah.
Thank you very much. So section 2, subsection 1 says the certification officer shall keep a list of trade unions containing the names of the organisations whose names were duly entered in the list of trade unions, and B, the names of organisations entitled to have their names entered in the list in accordance with this part. And when one goes to section 3, which is on the next page, we see the means of applying to be entered into this list. An organisation of workers, whenever formed, whose name is not entered in the list of trade unions may apply to the certification officer to have its name entered in the list. And if we go down to subsection 3, please, if the certification officer is satisfied that the organisation is a trade union, B and C, he shall enter the name of the organisation in the list of trade unions. I focused on 3A because in order to be satisfied that the organisation is a trade union, we need to go back to section 1 of the Act, which is a couple of pages back for Lord Justice Underhill, and page 36 for those with the insert. And the meaning of a trade union in section 1 is that it means an organisation which consists wholly or mainly of workers of one or more descriptions and whose principal purposes include the regulation of relations. Now, that part of the definition, which consists wholly or mainly of workers, is important for this appeal because it takes us straight to the section of the Act that defines workers, which is section 296, which should be on page 219 or 335 for those without the insert.
Funny enough, I've just been handed the insert, so there you are. I'm still not going to change horses now. Yes, and various others.
Yes, I'm very grateful. So section 269 defines worker as meaning an individual who works or normally works or seeks to work under a contract of employment or under any other contract whereby he seeks to undertake or perform personally any work or services for another party to the contract who is not a professional client of his, or then that subsection deals with government employment, and then we have employer defined, which doesn't matter for our purposes. So we see straight away the reference for the domestic UK definition of worker as needing a contract. The appellant argues that the refusal by the CO to enter it onto the list of trade unions engages the Article 11 right to form a trade union, to join a trade union of choice, and the opportunity to access the right to collectively bargain.
Can you just give me a moment? It engages the Article 11 right to join a trade union.
To form one.
To form one.
To join a trade union of choice.
Yeah.
And by being listed, the opportunity to access the right to collectively bargain.
Yes, that's not quite right. Access the right to require the employer in certain circumstances to recognise for the purposes of collective bargaining.
In terms of the opportunity to access, Lord, what I'm referring to is the gateway that listing provides to go forward to seek other rights under the 1992 Act, of which we have said throughout collective bargaining is the key relevant.
Now, I'm sorry to be pedantic. It's not just the right to collective bargaining. It's the right to require the employer to collectively bargain with you, or at least to recognise you.
Very grateful.
But it is an important distinction because they've got the right to collectively bargain.
We'll come to that.
Yes, I'm sure.
The refusal, we say, also engages Article 14, but I'll come to those points a little later on. For now, I wish to go straight to the question as to who benefits from trade union rights under Article 11. And we say there is no requirement to be a worker under the domestic definition in order for the Article 11 right to be engaged, and therefore we submit that there was between foster carers and their usually local authority employers an employment relationship in respect of which the Article 11 right is engaged. And I'd appreciate it if the court could go to page 93 of the core bundle.
Sorry, will you just indulge me in something which almost certainly isn't relevant, but I was just finding me, because I haven't actually reminded myself. Listing is different from a certificate of independence. Are you coming back to that?
It is, but I can tell you very shortly. Once you're listed, you can then apply for your certificate of independence.
Yes.
Section 6.
Yes, that's right. All I really wanted to remind myself of is a matter of history. Has that always been the structure, or was it originally the case that the certification officer kept a list of independent trade unions?
Lord Hendy dreams about these things every night. So I'm going to leave the history of pre-1992 listing to him.
Okay, we'll ask him when if I haven't lost interest by then, when he's on his feet. Thank you.
But for your Lordship's reference, Authorities Bundle, page 42, is section 6, which is the application for a certificate of independence. And that makes it clear a trade union whose name is entered on the list of trade unions may apply to the certification officer for a certificate that it is independent. So that's another stepping stone. We're not concerned with at this stage. So at core bundle page 93, paragraph 6, one sees the submission made to the EAT about employment relationship. And the second line there reads, the principal submission made by the appellant, the IWTB, in support of their contention that Article 11 is engaged, is that notwithstanding the absence of any...
I think you said 93, it's page 92, isn't it?
It's, as long as you're on paragraph 56. then we're on the same.
That's fine. Does that mean, though, that our bundles have different numbers?
Let's see how we go.
Okay.
The principal submission made is that Article 11 is engaged, and that notwithstanding the absence of any contract, there is between the foster carer and the foster care provider or local authority a clear employment relationship in respect of which the right to form and join a trade union under Article 11 is engaged. So we will say there is an employment relationship between foster carers and their employers. Before I move on to those arguments, I should mention that the IWGB makes the submission that everyone benefits from Article 11 rights, not just those who are in employment relationships. We're not dissenting from that, but are going to focus on the next limb of the argument if you're of the view that an employment relationship is required.
Is employment relationship here is being used in an Article 11 context, so it, not necessarily employees, but could be workers.
Absolutely.
Yes.
Absolutely. And, my Lord, we will take you to the definition of employment relationship, which has been used in the Strasbourg authorities, which, as we will show you, is identical or almost identical to the definition used in EU law. First point to make is that we know a contract is not required in order to be in an employment relationship from the Strasbourg case of Syndicatal Pastoral Selbund. That case was before the EAT, about Romanian priests. Since we're on that part of the EAT decision, I'll take you to the summary of that case there, please, at paragraph 57 in the decision. In that case, 32 Orthodox priests sided with others to form a trade union called Pastoral Selbund, the Good Shepherd. The union made an application to be granted legal personality and entered on the register of trade unions. Application initially granted. However, the Romanian appellate court revoked that registration on the grounds that the establishment of the union would be contrary to the Roman Orthodox Church statute prohibiting priests from setting up associations of any kind. In relation to the applicability of Article 11, the European Court of Human Rights held as follows. And halfway down 141 on that same page, the court said the only question arising here is whether such duties, notwithstanding any features they may entail, amount to an employment relationship rendering applicable the right to form a trade union within the meaning of Article 11. And the paragraph 142, in addressing this question, the Grand Chamber will apply the criteria laid down in the relevant international instruments. In this connection, it notes that in recommendation number 198 concerning the employment relationship, the ILO considers the determination of the existence of such a relationship should be guided primarily by the facts relating to the performance of work, and it is the remuneration of the worker, notwithstanding how the relationship is characterised in any contrary arrangement, contractual or otherwise, that may have been agreed between the parties. So, pausing there.
Substance, not form.
Substance, not form, is the very quick way of saying it. You don't worry about the label. And I believe it's not an issue that not having a contract makes no difference to whether you do have an employment relationship.
Well, anyway, isn't that what was decided in Gillam?
Yes, and of course in Gillam they were able to rely on O'Brien and the MOJ, where the case had gone all the way to Europe and back, in order to
Yes,
get that guidance that judges are in employment relationships. Lordships may have noticed that the EAT decided not to reach a decided view on this question. They felt there was insufficient information, in particular on the issue of remuneration, in order for them to conclude that matter. They didn't rule out an employment relationship if, for example, at some point a wage work arrangement was found. And it's at paragraph 70 of the EAT decision, page 97 for your Lordship, I believe. Paragraph 70, the EAT said, in our judgment, no clear conclusions can be reached in respect of the position as it applies generally to foster carers, save that to say that while the majority of foster carers in the UK receive small amounts described as a fee on top of their allowance, many foster carers in the UK do not receive any fee at all. The amount of the fee when it is paid does not appear to bear any real relationship to the amount of work done. As to the foster carers who are members of the appellant, there's no evidence they receive any remuneration at all, apart from the allowance and the retainer fee. Based on this limited information, we consider there is force in Mr. Collins' submission that, at least in relation to the foster care agreement before us, the arrangement does not appear to be one representing remuneration for work done. However, insufficient facts for us to determine the issue. Determination of whether there is an employment relationship will involve a multifactorial analysis, including whether there is remuneration for work done. No analysis of that type in the certification officer's decision, which was decided solely on the basis of there being no contract. So our grounds take issue with that finding, and they say there was enough before the EAT to find that there is an employment relationship between foster carers and their employers, and the positive finding ought to have been made. And I'll explain why that is our submission. The test for an employment relationship is quite simply a person performs services for and under the direction of another person, in return for which he or she receives remuneration. We get that from the ILO recommendation 198, which we've just referred to in the extract from the Pastoral Selbund case about Romanian priests. But it is, in my submission, identical to the EU definition, which my Lord Justice Underhill has recalled as in issue in Gillam and indeed O'Brien. May I give your Lordships, just for your reference, you don't need to turn it up now, the reference for the ILO recommendation 198, it's Authorities Bundle 568. So our submission is there were numerous sources of evidence before the EAT for it to make a positive finding on what foster carers do, and secondly, they erred in the way they approach the question of remuneration.
Well, what do you say the irreducible minimum is that is found in the judgment, which we can then say, adding these things up, creates an Article 11 engaged right? What's the bottom line that you have to get over? You obviously say it's quite low, but what is it?
We say that foster carers work for the local authority and receive remuneration for their services.
So it's two things. They work for the local authorities.
Yeah.
Be like that's the direction of the provision of service.
Absolutely.
Secondly, do they receive any money?
Yeah.
Regardless of its quantum?
Right.
It doesn't matter whether it's local authority or an agency. The irreducible minimum is performing services for reward.
But as I understand it, the difficulty that the EAT found was that the evidence that they summarised there is that it isn't clear they receive any reward.
Well,
to receive repayment of expenses is not the same as reward, or may not be. You need to look more carefully at these rather odd arrangements see what really the character of the payment is. If there was a fee in all cases, that would be much easier for you, but there isn't always.
Absolutely not. It's not uniform across the UK whether foster carers do get a fee or not.
Suppose they only get suppose they only get the allowance.
The allowance is enough in our submission.
Well, suppose the allowance could be shown on a careful examination to be no more than repayment, admittedly on some approximated basis of the expenses of bringing up a foster child. Would that be remuneration or reward? It's not a reward.
Let me clarify that the allowance, although it's said to be there for the cost of bringing up a child, that's actually distinct from the expenses that foster carers get. So, for example, if it's a birthday party and you spend £55 on the present for the foster carer, you're entitled to get that claimed back. You put in a receipt for it. Or suppose you go to the Isle of Wight over a bank holiday, you get recompensated for those kind of things.
That may be special expenses, but my understanding is that paying for a child's food, perhaps the most obvious, but their travel to school, their ordinary clothes, you don't claim for those as expenses, do you? Those are meant to be covered by the allowance.
The allowance, it is said, is to cover the cost of the child. But I'm going to take you...
But sorry, quite. But I mean, doesn't that mean your point about expenses isn't an answer?
You get the allowance regardless of whether you're feeding your child caviar or baked beans on toast.
Well, I understand that, but that's simply because for convenience it's easier to have an approximate amount. The point is the character of the payment, and this doesn't appear to be a sham. It may be that obviously you may, if you're very careful, manage to make a saving, or if you're not very careful, it may cost you more. But it's never intended simply to repay the costs, and we don't have to decide this point. Well, you say we do, but the point is that the evidence is very unclear about all this. It's at a very high level of generality, and isn't that what the EAT felt was the inhibition on them making a finding?
My lord, what the EAT did wrong was not to focus on what remuneration actually means within the description of an employment relationship. And I'm going to take you to a couple of different cases where the pay for services rendered is something not what one would think of as normally being wages, put like that, but it still doesn't matter whether the pay you get is proportionate or indeed whether it can be said to represent due pay in return for the services rendered.
So another thing you say, it doesn't matter whether it's a pure defrayment of cost, it's a payment.
Absolutely.
Precisely what it goes to, whether it's a cost, whether there's a profit margin is irrelevant.
Yes. Before I get to, so I'm going to address you firstly on the control or direction point. Are you carrying out services for the local authority or the agency? Secondly, on remuneration. And thirdly, on the point, in response to what the Secretary of State and certification officers say, is it work? Because the Lordships may have seen from the other side the submission, this is caring, not working. So I need to address you briefly on that. So our first point under employment relationship head is the requirements for the foster caring to be done is indeed under the direction of the local authority. And the first way we see this is from this concept of delegated authority, which comes up again and again in the various reports before the court, dealing with tensions which arise in the foster carer and local authority relationship.
Sorry, just picking up my Lord's point. Whenever you say local authority, we can say or agency.
Absolutely.
Okay.
Thank you. So This concept of delegated authority arises because when a care order is made, parental responsibility transfers from the birth parent to the local authority. The parts of the Children Act under which that happens and the occasions when some parental responsibility stays with birth parents as well need not concern us here. What's important to grasp is parental responsibility never transfers to the foster parent. If a child's adopted, then the adoptive parents acquire parental authority, but that's not the case for foster parents. And for that reason, local authority allows foster carers to take some decisions without having to be asked every single time, and that's known as delegated authority. That leads to all kinds of tensions, as I've said, over when and what does the foster carer have to get permission for from the employer. And I'm just going to take you to one or two instances of where we see that. Could I ask you to go to the guidance on fostering services in the authorities bundle at page 448.
Are you able to tell us which bundle that's in?
I believe it may still be bundled.
It is, yeah. Thank you.
The 448 is from the volume 4 of the guidance and regulations dealing with fostering services. And when you found page 448, please, it's paragraph 315 and 316 I'm focusing on. And what the guidance says at 315 is that arrangements for delegated authority should be given particular scrutiny when children are confirmed long-term or permanent placements, and attention given to how responsibility is shared in order to reinforce and support the long-term bonds and attachments which foster carers will be expected to build up with a child. In all placements, particularly those which are long-term or permanent, what's appropriate to delegate to the foster carer and what the parents are prepared to delegate to the local authority may change. Agreements about delegation of authority should therefore be regularly reviewed through care planning and review meetings, taking into account the views of birth parents, the child, the foster carer, and the legal status of the placement. Any changes should be recorded in the placement plan. And then paragraph 3.6 deals with how that works where an agency is involved. And just the first sentence of 3.17, please. Difficulties obtaining permission for sexual is often highlighted as a particular concern by looked after children. And I just highlight that, my lords, because it's a very common occurrence that children want to go and stay the night with their friends, perhaps at the weekend or so on. In the ordinary course of events, you say to your mum or dad, can I go and stay at so-and-so's? They say yes or no, there's too much homework. Here, there's a tension about can the foster carer just say yes or no, or do they have to ask their social worker in advance to get that consent? One more reference, please, my lords. It's in bundle.
Just before we move away from
Yes.
that, I'm just skipping to the introductory parts of that document. I think
Yes.
it's paragraphs 1.1, 1.2, and probably 2.1, which explain how the delegation flows from section 22 of the Children Act, and really explain the legal basis for your conclusion that it's the local authority that has the parental duty.
Absolutely. And if, my lord, also it's section 33 of the Children Act, for your information, which deals with what happens to parental responsibility once a care order is made. We don't have section 33 in our legislation section, but we can hand a copy up.
You're plainly right. The obvious distinction between adoption and fostering.
Yes.
In broad headlines, are there sort of reserved powers which the local authority never allow the foster parents to decide on?
Well, suppose a foster carer says, I want to change your name. I want to call you my surname from now on, or perhaps I want you to have my grandfather's first name. That's kind of the situation that the foster carer, but that would never be delegated. One would always have to go back to the local authority for that. Of course, if the foster carers became adoptive parents, the power shifts, but we don't need to trouble ourselves. So, could we look at the supplemental bundle, please, volume 2, at page 747. This extract is from the Fostering Network's State of the Nation survey. And 747 has at the top paragraph 332, foster care authority. It reads, while foster carers look after foster children on a day-to-day basis, they often have the least authority out of all those in the team supporting the child. The source of the tension about where responsibility and authority lie in foster care is the fact that the corporate parent is the local authority and is removed from those who have day-to-day responsibility for the care of the children of the foster carers. The local authority or trust is often discharging its role as a corporate parent within a large bureaucratic and regulated structure, and one where a culture of blame can create a real sense of anxiety about delegating decisions to foster carers. The impact of this is ultimately on the child, and it can hinder their ability to participate in normal family, school, or social activities. So we add that to the information before your lordships to show that, firstly, there is a hierarchy between the local authority as the employer and the foster carer, who is the worker, who needs to seek permission for key aspects of care. And secondly, to show the distinction between foster parents and birth parents. Of course, the birth parents may have all kinds of tensions about, is the sleepover appropriate or not? No, you've got too much homework. But it's a completely different issue from, do we have the power to allow you to go? Other issues relating to control and direction by the local authority involve supervision, checks and assessments of foster carers through local authority social workers. This information was all before the EAT, and a few references as to those occur in, firstly, the national minimum standards for foster carers at number 20, which is in your authorities bundle at 532, please. I'm sure that's the first volume.
A good tip for those putting bundles together the next time to write on the back which pages they cover, but we'll learn pretty quick.
What we can do over lunchtime very easily is do what my junior has just done for me, my lord, which is ready retina of you to work out exactly where's what. So we'll.
Oh, thank you. That's very hard. I'm
pass up
actually just to
sanitised
write on my
post-it.
back 1 to 863 right now. So anyway, sorry. Yep.
So the national minimum standard number 20, here at page 532 of the authorities bundle, is about learning and development of foster carers. and it deals with the framework of training and development, which can be used to assess performance and identify training and development needs. I don't need to take you through all the detail in that standard, but one can see very quickly the detail involved that the local authorities are expected to have in place.
It's the thrust of this submission to demonstrate that the foster carer carries out a very great deal on behalf of the local authority, corporate parent. Is it really to demonstrate the nature of that relationship or the extent of it?
It's to demonstrate that they're not free agents, but they are under the direction and control. So it's showing that although they may have autonomy as to what's for supper on a Tuesday night, they're not quasi parents in the way you would understand a birth parent role. And if we could move forward to page 534, standard 21. We see there the standard relating to the supervision and support of foster carers. And those paragraphs deal with achieving the outcome that foster carers receive the support and supervision they need in order to care properly for the children placed with them. And if your lordships could turn to page 535, paragraph 21.8, one sees the role of the named qualified social worker, who needs to do a number of tasks, including meeting, supervising, ensuring child's needs being met, offering support and a framework to assess the carer's performance and develop their competencies and skills. And at the bottom of that paragraph, 21.8, you see foster carers' files include records of the supervisory meetings. And 21.9, the supervising social worker ensures each foster carer he or she supervises is informed in writing of, accepts and understands and operates within all regulations and standards and with policies and guidance agreed by the fostering services. Paragraph 21.10 deals with handbooks or resources covering policies, procedures, guidance, financial information, legal information and insurance, which is updated regularly. We submit that there is nothing novel about having an employment relationship where you indicate autonomy in the way you work. And the two cases I can quickly take the court to demonstrate this point. The first is the case of O'Brien, where the argument that recorders aren't told what to do by anyone was relied upon by the MOJ in order to try and avoid a finding being made that judges work under employment relationships. I'd like to take the court briefly to the Supreme Court decision in O'Brien at Authorities Bundle, Volume 2, page 1138. About 4 lines down into paragraph 34 that I'm looking.
So give me the page in
1138, please.
Thank you. And which paragraph?
Paragraph 34, 6
Yep.
lines down. This is describing the MOJ's argument. Fundamental to the concept of judicial independence was the fact that judicial office holders exercise their function wholly independently of influence or direction by any minister, government department or agency. Court of Justice has, however, made it clear that the principle that judges are independent in the exercise of their function of judging is not as such called into question by extending to part-time judges the scope of the principle of equal treatment to protect them against discrimination as compared with full-time workers. In these paragraphs, as reference to the ECJ decision in O'Brien, in these paragraphs the court was in effect endorsing the observations of Advocate General Cocotte, where she said at 51 of her opinion, I would point out that's difficult to determine how the rights granted by the framework agreement in general and an entitlement to a retirement pension in particular can jeopardise the essence of the independence of the judge. On the contrary, entitlement to a retirement pension strengthens the economic independence of judges and thus ultimately also the essence of independence. Independence, in the terms of the essence of an activity, is not therefore an appropriate criteria for justifying the exclusion of a professional category from the scope of the framework agreement. And we see from paragraph 35 that because of that, the Ministry of Justice did not pursue the argument that the principle for the independence of the judiciary justified according a different status for the purposes of the framework agreement to recorders from that which governed ordinary departmental staff of the civil service. And this is the sentence I emphasise in particular. The fact that recorders are not subject to direction or control over the decisions they take in the performance of their responsibilities of their office does not deprive them of the protection against discrimination that the framework agreement was designed to provide. And we have another case, indeed about foster carers, which says a similar point, but refers specifically to the fact that foster carers do that work within the home. And that's the case of Sindicatal Familia Constanza, the Court of Justice case, which finds that foster carers are workers. And that's in your authorities bundle, volume 4, if you've got 4 volumes, otherwise it'll be volume 3, at page 3005.
Say the page number in 3005.
3005, please.
That's tab 98. Yep. Oh, yeah. Thank you.
So this case is dealing with Romanian foster carers who don't work, my lords, in identical circumstances to UK foster carers, but there are certain points in the paragraphs I'm taking you to which are pertinent for this submission. So paragraph 42 states, it follows that an employment relationship implies the existence of a hierarchical relationship between the worker and his employer. Whether such a relationship exists must be assessed on the basis of all facts and circumstances characterising the relationship between the parties. In the present case, it's clear from the order for reference that foster carers must provide the principal on a continuous basis for the care and education of the children placed with them by a public authority, and in return for that they receive remuneration. Going to paragraph 44, moreover, according to the national legislation, the foster parents must allow the specialist service for the protection of minors, with which they concluded a contract, to supervise their professional activity and to assess the development of the child placed with them. 45, it follows from all of these factors, that the particular applicants are, with respect to the public service to which they are contractually linked, in a hierarchical relationship evidenced by permanent supervision and assessment of their activity by that service in relation to the requirements and criteria set out in the contract for the purpose of fulfilling the task of protecting the minor, which is conferred on that service by law. And here's 46 is the one we emphasise in particular. Such an assessment is not called into question by the fact that foster parents, such as the individual applicants, have broad discretion as to the daily performance of their duties, or that the task conferred in them is a task of trust or a task of public interest. 47. In addition, the fact that the work performed by foster parents is largely comparable to the responsibilities taken on by parents with regard to their own children is not, in the light of what was noted, 43 to 45 above, sufficient to prevent those foster parents from being qualified as workers within the meaning of Directive 0388. That's the Working Time Directive. And therefore those foster parents must be regarded as workers within the meaning of the directive. For your information, my lords, in this particular case, when the court came to look at the provisions of the Working Time Directive, it felt that it didn't apply to the foster carers for specific reasons to do with their work. But here we're not concerned with does the Working Time Directive apply to foster carers. We're looking purely at the employment relationship definition and whether foster carers in the UK fall within it.
I see that, though quite not for this stage in your submissions, is that if the solution which you seek is effectively a decision that they're workers for all purposes, going beyond the specifically Article 11 context, there might be difficulties, mightn't there, in saying that the working time regulations did not apply to them?
Well, we're not saying this court should make the finding of an employment relationship that a foster carer can take with them to any right from now on. Far from it. We ask you to read down the purposes of listing. And what that means is, even on another occasion, a foster carer says, I want to bring a claim in a totally different, from different cause of action, based on a different right, say outside the trade union field altogether, and I'm going to say I'm a worker because I have an employment relationship, but I need to ask the court to read down in some way the definition of a worker included in a contract, as the court in Gillam, for example, was required to do. When that balancing exercise is undertaken, if there are points which relate to the facts in question, which are different from here, of course, the employer, if it is the employer who's required to respond to the foster carer's cause of action, would be able to bring all those points.
No, this is perhaps a point for later in the argument, but since, just indulge me, so does it follow you're saying that the reading down that you seek wouldn't necessarily apply in what I might call ordinary employment legislation, but would it apply to all employment rights which engage convention rights? So Article 11, most obvious, but in certain circumstances might also be Article 8.
The basic definition of whether one works under an employment relationship might apply, but that wouldn't be the end of the question in terms of according rights over other provisions, my lord, because in order to do that and rely on the Human Rights Act, one would have to say, firstly, is the discrimination I'm arguing about, or the breach of convention rights I'm arguing about, justifiable? And different factors come in. And when you come to reading down and you look at the fundamental features of the legislation, there would be, for example, as there were in this case, separate arguments to be made in relation to the specific right relied on.
Well, let's go to holidays, which feature a great deal in the evidence in this case.
If a foster carer were to bring a claim saying, I want the same holiday requirements as every other worker is required, it gets in law in the UK,
Yes.
then the factors that we see coming into play here as to is the Working Time Directive apt for applying to this kind of work, and to the derogations that the court looked at in this case, which I don't have time to take you through in detail now. Those would be up for the court to determine. We cannot seek to bind all rights for that purpose. We don't seek to do so.
I understand why you're making those points, but I was asking a more limited point. Simply whether it follows from your submissions that in any case where the rights in question engaged, or the issues in question engaged Article 11 or Article 8, perhaps occasionally, difficult to think of any other examples, Article 6 or Article 10. The Article 10 is a real possibility. In fact, very much so, because of Gillam. In any such case, the definition of worker would have to be read down to correspond to the convention concept of an employment relationship. Of course, other questions would then follow, but the convention would then be in play. And you,
absolutely.
Yes, okay, thank you.
And my lord, that's why when I eventually come to dealing with Section 3, at the end of my submissions, you will hear me say that the Secretary of State has got it entirely wrong when he says we're asking you to read in this concept of worker across the board, and it would require the statute to be rewritten. It's far, far more modest than that, what we seek by this. So our last point on the control of the foster carer by the local authority is to make the point that if a foster carer gains worker status for the purposes of listing, there's no evidence that that would change the essence of the role or do away with the checks and assessments and supervisions we've highlighted. And nor would foster carers become less independent in their everyday tasks if they gained worker status for listing purposes. They're not free of direction, and the EAT didn't find as such.
Can I just ask you as a matter of principle why the degree of discretion conferred upon the worker is relevant? And you can have a contract where you can confer upon an employer or an agent a very broad or a narrow discretion. It depends upon the context and the circumstances. As I understand, all the court was saying in 46 in the European Court case was that the fact that there's a conferral of a broad discretion doesn't disqualify. But they didn't say an even broader would or a narrower would. And is that really a determining factor, the extent of the discretion?
My lord, it's a point that's made against us.
I understand that.
And it comes up very often in these kind of cases.
Which is why I'm asking really as a matter of fundamental principle, what is the relevance of the extent of discretion to the issue we have to decide?
We say here, because of the nature of the work, you can see very clearly what the supervision, direction and control is. And the fact that you have delegation may change between different local authorities depending on different children matters not.
The extent of the delegation of authority under a contract or under some other arrangement will simply be fact and context sensitive.
Yeah. It doesn't change the fact, in our case, the local authority retains parental responsibility.
I suppose if you go to a very extreme example where there's absolutely zero control, it might test the limits of that.
Well, that point was argued in O'Brien for many years.
Yes.
Judges do it on their own.
Yes.
You know, no one's telling them what to do ever.
Yes.
And that's why I took you to the point where it was eventually dropped by the MOJ.
Yes.
But at the risk of spelling out the obvious, the reason why it's a question you have to address is that in the Strasbourg jurisprudence, which bases itself firmly on ILO 98, 198, I'm sorry, there's what you might call a multifactorial definition of an employment relationship, not actually all that unlike the one we've developed in common law. But one element in which is the fact that the work is carried out according to the instructions and under the control of another party. So it's something you've got to consider for the purpose of the Strasbourg jurisprudence, but it's not determinative either way.
No.
You could have, well, it's not determinative either way.
And what 198 also says is that you look to see which of the indicators are in existence, and you make a legal presumption that there is an employment relationship if one or more of them is present.
It's a little bit looser than that, but yes, it says members should consider the possibility of defining specific indicators which would then be presumptive. Yeah, but yes.
I need to move on to remuneration. The EAT was concerned that the receipt of a fee wasn't consistent across the UK. Although the allowance is intended to compensate for the cost of looking after the child, it's not the same thing as expenses. In particular, it's paid at a flat rate, not matched against receipts for costs incurred. It's important in our submission to focus on the definition of remuneration in relevant case law, focusing on whether worker status is established. And we will take you to 2 Court of Justice cases where a low payment that would not generally be seen as a wage does count as remuneration. And the first of those cases is called Phenol, and it's in your authorities bundle in volume 4 at 2946, please. So Gérard Phenol was a disabled person who attended a work rehabilitation centre known as La Juven from 1996. That centre offered opportunities for work activities, social education support, medico-social support and living arrangements to encourage personal development and social integration. Mr. Phenol provided various services and he was paid a sum below the French minimum wage and received paid annual leave. He wasn't an employee under French law, and after he went on sick leave and then left the centre, and subsequently he sought payment in regard to leave he hadn't taken before he'd gone off sick and leave he hadn't taken when sick. And the Court of Justice said the fact that he'd been paid below the French minimum wage for his services didn't prevent his being a worker because it was a real, genuine activity. And I would ask the Court to go to page 2954, please. That's paragraph 27. And the court here, we're looking at the EU definition of worker, but we say there's much you can take from how the criteria were examined. The courts say at 27, they recall the definition of worker, and they say 4 lines down, any person who pursues real, genuine activities to the exclusion of activities on such a small scale to be regarded as purely marginal and ancillary must be regarded as a worker. The essential feature of an employment relationship is that for a certain period of time, the person performs services for and under the direction of another person, in return for which he receives remuneration. And I'd ask you then to jump to paragraph 33 and 34, please, on the next page. Where the court says, it's clear from the file submitted to the court the activities performed by Mr. Phenol within the economic and social programme of La Juven were carried out in return for remuneration. In that context, it should be noted that the fact that his remuneration was substantially less than the guaranteed minimum wage in France can't be taken into account for the purpose of classifying him as a worker. According to the court's settled case law, neither the level of productivity of the individual concerned, nor the origin of the funds from which the remuneration is paid, nor even the limited amount of that remuneration, can in any way whatsoever affect whether or not the person is a worker for the purposes of the EU law. And then if we could jump to paragraph 42, please, where it says the National Court must in particular ascertain whether the services actually performed by Mr. Fennell can be regarded as forming part of the normal labour market. So we submit what is being said here. It's not whether what is paid is proportionate to what the work is done that's important. It's rather, is the work of some value. And taking that back to our situation, clearly foster care of work is of value to the local authority who's responsible for the child in care's welfare at all times, especially when fostering arrangements for placements are made. So in Fennell, the question was whether the work done in a rehabilitation centre was a genuine economic activity. Foster carers' work is clearly part of the labour market. If there
Well,
is
is it? You say clearly. That's what the big question.
Well, we say it is clear because it has a cost associated with it, in that if there is no foster carer available, then the child may have to go into residential care, which is a part of the local authority budget. So greater expense may be incurred if there's no foster care available. And the other reason why it's part of the labour market is all the structures that we've seen around and within foster caring, the support, the supervision, the performance, the training, all those are interlaced with part of the fostering service of the local authority, social workers working with foster carers and assisting them in the performance of their tasks. Those people have a cost attached to them as well, and it simply cannot be said there's no economic value to the work. You may believe that the local authority gets a rather good deal out of this economically in terms of the minimal financial outlay. That's why I mention the other factors that go into the whole system. You can't just say because foster care is so badly paid, it's not part of the labour market. The individuals, the social workers who support the foster carers, have costs attached to them as well. So we submit that on this basis, receiving even an allowance qualifies as remuneration. There's no requirement for the wage to be proportionate to the work done, contrary to what the EAT said. I want to take you briefly to a...
Can the indirect benefit to the local authority really be what you get out of this Fennell case?
Mm-hmm.
Suppose some foster carers weren't paid at all. There would still be a huge benefit to the local authority. Would that be enough to bring the case within
My Lord,
this
the
principle?
case I'm just about to take you to deals with a situation where reward is not just financial. So let me take you to this case briefly called Payir, which is about a Turkish au pair working in Britain.
Foster carer enables the local authority to satisfy its statutory duty under the children's.
I'm so sorry, my Lord, could you...
Yes, the foster carer permits,
Yeah.
or is the agency through which the local authority satisfies its duties under the Children Act.
Yeah. Without placing that child in care, it can't...
But it's the point, yes, it's being paid for the performance of a statutory duty. That might be said to be sufficient benefit in of itself, direct or indirect.
Yeah, we confirm. So the case of Payir in your authorities bundle in volume 4 at page 2712 is about whether au pairs working in the UK have worker status. And the issue here was whether was it relevant that pay for the au pair came in the form of board, lodging and pocket money, and indeed included the benefit here of simply learning a language while based in the UK. So could I take you straight to page 2733, please? And that's paragraph 28. And you'll see there that the essential features of the employment relationship are rehearsed in that paragraph, much as they were in the Fenol case we just looked at. And then going on to 31, we see that it says Miss Pierre offered services which constitute genuine and effective economic activities. According to the case file, they worked under the direction of an employer and received remuneration in return for their services. She worked between 15 and 25 hours a week. It's not contended that activities were purely marginal. According to the description given, the activities display the characteristics necessary in principle that those who perform them are to be regarded as workers within the meaning of the immigration rules. And could we now turn up 2736, please? 2736. At paragraph 45. What the Court of Justice says here is that provided that, in particular, that the genuineness of the work performed by the Turkish nationals in question is confirmed, the fact that they have entered the students to pursue a course of studies or as au pairs with the aim of mastering the language of the host member state is immaterial. So what we take from that is that even though the au pair receives pocket money for her wages, it can't, that money cannot be said to be proportionate, for example, for an hour-for-hour basis on the work she's carrying out. She gets board and lodging too, and the other benefits, for example, learning a language. Those don't prevent her being a worker, because again, the emphasis is on the genuine nature of the work. And
you don't. Sorry. Are you going to show us what the actual factual basis was as regards the payment? I mean, just looking at the head note, it does say she received a weekly payment. You call it pocket money, but that's, I don't know what you mean by pocket money. It's either money or it isn't.
let me just take, I think it's in the AG.
Paragraph 13. Here, board and lodging and £70 a week.
Thank you, Manuel. I'm very grateful. Also in the AG's opinion, at paragraph 29, at the very top of page 2719, bottom, it was start at the bottom of 2718. For an au pair, the au pair placement is associated particularly with benefits that go beyond remuneration for activities she receives in the form of board and lodging and pocket money. An au pair's status of worker can't be excluded on the ground of that circumstance alone.
Well, that's fine, but you're obviously going to cite this case anyway, but you cited in particular in answer to my Lord's point about what if there was no payment at all. Looking at this, this is clearly not a case that there was no payment at all. It helps you on the point about proportionality, perhaps, though really no more than the previous case.
My Lord, it helps me in one more way that I could just emphasise while we're on that point. Here, there were benefits going beyond pure monetary remuneration.
Yes, but it's not saying that those benefits count as remuneration. That just wasn't one of the issues in the case.
Well, it is saying when you look at, can you look at the top of 2719?
This is in the AG's opinion.
It is in the AG's opinion. Up 3 lines down to the top of that page, Other employment relationships too may be associated with a worker that go beyond the remuneration received. In the case of work abroad, that may be the opportunity to learn a language, or generally the benefit represented by the acquisition of professional experience.
Yes, but that's going to a slightly different question, isn't it? The question being addressed in 29 generally is that the key point about an au pair relationship, as it's normally described, is someone comes to a household to learn the language and for cultural exchange. And what the Advocate General is saying, yes, but that doesn't mean that it may not be a worker relationship. Fine, I've got no problem with that, but it isn't quite the point that my Lord was putting to you, or
Well,
indeed...
First point we would say is, for the purpose of this appeal, we don't have to deal with a situation where there is no money exchanging hands at all, because that's simply that's not the case with foster carers, that they work with no financial reward whatsoever.
Of course, but my Lord was putting it to you as a test of your proposition that there's an economic benefit to the local authority, as if that meant that it was part of the labour market. And surely the point of the question is that there might be an economic benefit even if there was no payment at all.
Well, our submission would be that the economic benefit received by the local authority doesn't have to equate in wages terms to what is actually received by what the foster carer receives. So in other words, if the local authority is getting a good deal, as one may think they do here, by not having to pay foster carers national minimum wage, for example, that doesn't mean any less that they're not part of the labour market, or indeed not engaged in genuine economic activities. And my Lord, it might be that if there was a class of workers who didn't receive any monetary payment for their work, but had associated other benefits, perhaps just board and lodging, for example, and they performed genuine economic activities, that they would argue they too were workers as they fell within this definition. We certainly don't rule that out, but it doesn't have to be determined as part of this appeal, because it's clear that foster carers do receive at least an allowance, and as the evidence before us makes clear, in many cases a fee as well. The reason why we
This wasn't about, this was not a case about employment rights, it was a case about immigration rights.
It was about immigration
No,
rights.
it was a right of access to the labour market under the Turkey-EU
Thank you, my lord,
accession.
absolutely.
Sorry.
But it's because the definition is identical.
Quite.
And the factors.
Yeah, I just wanted to see the context, but thank you.
But just on that point, the cases, the European Court cases you cited to us either concerns Working Time Directive, or as here the EU-Turkey Association Agreement. I suppose the latter concerns right of access to a labour market. The former is concerned with those who are in the market and what their minimum rights are. I suppose they're not a million miles away from Article 11, which is slightly, it's about the rights of people in a market, in a labour market.
For the purpose of seeing whether they fall within the definition, my lord, those differences matter not in our submission. You're still looking at those essential characteristics and whether they're made out. And the nuanced examination of remuneration in those two cases we submit is helpful, because it shows that one must look at the way foster carers are paid, not in the basic wage for work situation. And there's a reference to, in the NERI report, which you may have seen referred to in the skeleton arguments, about how reticent foster carers are in saying they're interested in the money, or that they have anything other than an altruistic cause for children. And NERI says that shouldn't be the case. There's no shame in saying you want to be paid. I'll give you that reference shortly. So I'm going to move on from this now, but we submit an allowance is sufficient to determine the existence of remuneration. The fact that the variance exists in terms of fee levels across the UK is immaterial to the finding of the employment relationship we seek. And we also make the point that the low wage is immaterial to whether remuneration is made out, as the question is the payment, however small, in relation to a genuine activity which is being carried out? Here we say yes. If you're not looking after a child, you don't get the allowance. It doesn't have to be proportionate or akin to a salary.
There is some case law, isn't there? Not asking you to have it at your fingertips, but those behind you might just see whether there's anything relevant about what exactly the word allowance means. I'm sure you'll say we should be looking at substance, not form. I take that. But still, it clearly was used in this context to suggest it's a payment of a particular character. And I think this has come up in the context of national minimum wage. I don't have the case at my fingertips. You needn't say whether you do or not. But could someone just see whether that may feed into the argument at some point?
We'll certainly look, my lord. Because of time issues, I'm going to...
Of course. No, I just wanted to flag that up. Thank you.
Could I just give you a reference to our skeleton argument to do with foster carers seeking better pay and why it means, why therefore the low level of remuneration isn't a point to be held against them. That's core bundle, page 49 to 50, paragraph 18. And that nary review reference about there being no shame in regarding foster caring as a paid activity is supplemental bundle, page 555.
And what was the other reference you just gave?
Our skeleton argument, the amended one, the first one, paragraph 18, core bundle, page 49 to 50.
Thank you very much indeed.
A very short point, my lord. Although the Secretary of State says an allowance is not a wage, when a foster carer is preparing a tax return for their self-employed status, they have to declare income or earnings. Of course, the tax classification is different from the employment system, but at Authorities Bundle, page 3094, I don't ask you to turn it up now, is the guidance for foster carers in terms of tax status.
So reference again?
3094. And I can be very brief, my lords, on addressing you on the government's argument that this is caring, not working. We have noted the obligations that go above and beyond that of being a parent, including being required to comply with ongoing supervision, seeking authority for all kinds of activities and training. We ask you to go back to that State of the Nation report in supplemental bundle 733, please. And the extract I wish to take your lordship to is 3 lines down the second paragraph, where the authors say, however, it is naive to ignore the fact that the trauma experienced by many children before they came into foster care may impact on their mental health, welfare or behaviour, and therefore we must also recognise that those tasked with looking after these children in a family setting, helping them to recover and thrive, require specific and enhanced skills, support and training above and beyond that of a parent, in order to do their job to the best of their ability and with the most successful outcomes. And we say there's simply no evidence which suggests that worker status for this purpose would turn a home into a workplace, which is suggested. any submission is part of a theory which denigrates the act of caring into some kind of domestic lifestyle choice rather than the highly prized skill we see referred to in the State of the Nation report. And to accept that looking after people is work, and valuable work, has never been more real than now, 2020, in our submission. And cared for children no more lose out when the fact of that work is acknowledged than a patient in A&E or an elderly person with dementia in a care home who has people working and caring to look after them. In our submission, the venue makes no difference. The subject of the care makes no difference to the fact that these are skilled activities. This is particularly so with vulnerable children. It's clear that the local authority needs to undertake checks on an ongoing basis, and that the care is done with affection and even love does not mean it is not work. That you're doing the work in the home makes no difference. And there's a distinction, we say, between the relationship with the child, which is one of affection, care, and love, and the relationship with the local authority, which is one where services are provided under the direction of the employer in return for remuneration. So we aver that, contrary to the EAT findings, there is ample evidence before the court pointing to the direction of the existence of an employment relationship, and that this court can feel confident to make that finding. That there wasn't before the EAT, or indeed before the certification officer, specific information about the few existing members of the trade union and what each of them did on a daily basis and so on, makes no difference, we submit, particularly in these circumstances, when the definition of the working relationship, the employment relationship, and how it applies to the profession as a whole is set out so clearly in the material before us, much of which has been provided by the Secretary of State for Employment. For Education. So, my Lord, moving on from the employment relationship question, I'm going to deal with the rest of the Article 11 arguments extremely, in an extremely summary way, bearing in mind the timing I have, and I don't want to overlap with any of Lord Pendy's submissions. The key point that the EAT focused on when looking at whether there was an interference with Article 11 rights was that it said the option for voluntary collective bargaining remained, even if this appellant was not listed. So that I want to address you on, very briefly, on why we say the EAT was wrong to conclude there was no interference with Article 11, as voluntary collective bargaining was not precluded. And our submission is that access to the voluntary system is not an effective protection of Article 11 rights for these few reasons. Most employers will engage in voluntary collective bargaining because they know that if they do not, they will have to go through the time, expense and detail of the compulsory collective bargaining system. Without the stick of compulsory collective bargaining, the incentive to come to the table to take part in a voluntary process simply does not exist. So, of course, voluntary collective bargaining may be possible, but it's not an effective alternative in our submission. To have an effective right, the trade union needs to have in its back pocket the chance of utilising the statutory framework under Talker. Next here, this workforce is decentralised and poorly paid, and the local authority, in our submission, will always have greater bargaining power. And this is not the kind of work where it's feasible for foster carers to shop around for better terms and conditions. So this is one of those particular situations where the absence of a statutory mechanism for compulsory collective bargaining gives rise to a breach of Article 11.
The collective bargaining rights would be sometimes with the employer and sometimes with the agency. Is that right?
Both those possibilities.
Can I ask a question really about the standard of proof? Do you have to show that they're denied something per se, in other words, the right to compulsorily collectively bargain, or that right is material?
We say the latter.
You say you've got to show that it's material.
Well,
or
we
just
have to show that we have to show that it's an effective right. Whether that's as high as being material, I actually doubt. But if we say the voluntary process is not an effective.
Oh, I understand that, but do you have to go that far? Or would you just simply have to point out that there is a distinction in law between a voluntary collective bargaining process and a mandatory?
That is simply pointing out in law there is the distinction. We don't have to put it as high as your latter suggestion.
No, sorry, my latter suggestion is lower. There's 2 points. One, I think it's common ground that there is a distinction between voluntary and involuntary collective bargaining here.
Yeah.
You're going on and saying that distinction is material and significant. Do you have to prove that, or do you simply have to say there is a legal difference between the two for the purposes of Article 11? You're denied a legal right, namely mandatory collective bargaining.
Yep.
You could say full stop, or then you can go on and say, and furthermore, it's material. We're losing something really significant.
Well,
how far do you have to go in law?
We say we don't have to go as far as saying we're losing something really significant, but in fact we are, for the reasons I've just set out.
There's always a dispute about materiality of some of these provisions, both in domestic law and convention, whether you have to show it's material, that which you lost, or not.
We say we can show it's material, although we don't have to. The next reason why voluntary collective bargaining is not an effective right is to do with restraint of trade, my lords. We submit there's a risk in engaging in voluntary collective bargaining without the protection of being recognised as a trade union. If you have that protection, you can take advantage of the benefit.
Sorry, can you speak up a little?
I'm so sorry.
Yeah.
If you're recognised as a trade union under Tulka, you can take advantage of the benefit of Section 11 of the Act, which gives you a guarantee of legality and avoids the risk of your activities being seen as unlawful by reason of restraint of trade. If you're not listed, it makes it difficult to show that you fall within the definition of a trade union and therefore get the benefits of Section 11. I don't have time to take you through those points in any more detail, my lord, but it's an important qualifier for the voluntary collective bargaining point. We also emphasise that the EAT found there could be meaning in collective bargaining even without a contract. And that's very important, how the significance of that goes to the lack of opportunity to collectively bargain being a breach of Article 11. I'm just going to give you the reference in the EAT decision where that is found. It's paragraphs 85 and 91, which I believe, my lords, will be your bundle 104 and 107. Moving on to justification for any interference found, I'm going to leave the test to Lord Hendy in its entirety, but I've got a couple of points to make about the legitimate aims put forward. The EAT dealt with these on paragraphs 115 to 121. We say the first legitimate aim, maintaining the distinction between those who are workers and those who are not, simply doesn't fall within the permitted derogations in Article 11.2. We know that occupational classification can't fall within Article 11.2. That's made clear from the farmer's case of Manole, which, for your reference, is in the authorities bundle at A2969, and it's paragraph 62 in particular that makes that point. Again, I don't have to go to that right now.
Okay.
And that so-called legitimate aim has no rationale related to the measure in question. How can there be, how can the need for a coherent system of trade union negotiations be assisted by the division between contracts and non-contract workers, where we have seen that there are clear criteria defining an employment relationship, and that provides a scheme as legally certain as identifying a contract. And we also note here, one is entitled in one's trade union to have some members without contracts. The definition is wholly or mainly of workers in section 1. And since we know from what the EAT has told us in paragraph 91 that compulsory collective bargaining can apply to those without contracts, the measure is even less related to the aim that is relied on by the Secretary of State. The second legitimate aim relied on is protecting children's rights. My learned friends will deal with the substance of this, but we simply point out for you now that none of the evidence before the court, whether from witnesses or in the form of the various reports, addresses the impact or potential impact on cared for children from their foster carers getting worker status for the purpose of listing. And that's what one would need to show. Not that they're getting employment rights across the board, or they're going to be away on holidays every few weeks. That's not the issue. None of the reviews address the impact for this specific listing purpose, and indeed there is no evidence going to that, and on that basis alone, that justification argument in relation to the second aim ought to fail.
Just to think about the first European court case you mentioned to us, as I recollect, where they found that the foster parent was a worker, but then held that the Working Times Directive did not apply.
That's right.
Wasn't it for the reason that if it did apply, you'd have to give them time off and downtime, which was inconsistent with the concept
With the role.
of a family or a parent, but it didn't prevent them from being a worker.
That's right. Because the court had to go through the two steps of the process. One, are you a worker under the general definition, and to the derivations within the directive, which apply to...
Well, there were specific derogations within the directive that either clearly did or at any rate could be interpreted as excluding foster care parents.
Exactly.
Okay.
When one gets to the way the EAT balanced the legitimate aims against the measures in this case at paragraphs 126 to 127, we submit 4 points, they've muddled the aim and the measure. And failed in respect of the first legitimate aim to relate it to Article 11.2. Secondly, although they found that they weren't in a position to reach any finding as to the position of children as a legitimate aim, when it came to weighing that up on paragraphs 1 to 6 to 7, they still held that point against the infringement of Article 11. If I could take you to page 121, please, for Condell. I think it's actually 100. Yes, have you got a paragraph 127 there, my lords?
Yes.
I'm grateful. So, the criticism and the error of law we say the EAT is falling into in particular here is, although having made a finding, they couldn't reach any conclusion on the position of looked after children, they still say the objectives outweigh the minimal intrusion involved, and that Parliament achieved fair balance. If you go back to paragraph 126, please. Despite them identifying what the first legitimate aim is, they don't identify how it falls within Article 11.2. So
Is there a possible reconciliation that in 127, as they make clear elsewhere, they are recognising the, I know you don't like this phrase, or someone doesn't like it, but we'll do for the present, the considerable margin of appreciation in this area, that although the court itself isn't in a position to make a finding about the, as it were, the cost benefit for the purpose of children, allowing foster carers to be regarded as workers, Parliament has done so, and there's no reason to think that their assessment shouldn't be respected.
We would say, and Mr. Burkham I'm sure will take this further, that in order to have carried that out, a best interests assessment should have been carried out.
By whom? By Parliament?
Well, firstly by Parliament, and that EAT should have acknowledged what had been done and looked at the ways that we pointed out fallen entirely short.
Sorry, when should Parliament have carried out a cost-benefit analysis?
When looking and preparing for this case and looking at the best interests of the child in terms of the Article 11 infringement, what we said to the EAT is the evidence before the court doesn't bear out the standard of scrutiny.
But by Parliament?
Yes.
I.e. in 1992, there should have been a white paper saying, looking at the definition of worker, this it's fine for this to apply to foster carers because ...
No, not by Parliament at the time the statute was drafted, but by government in preparing the response to this case. We had the statements by the witnesses that were put before the court, and they didn't address the relevant point here. So, for example, at its simplest, they looked at the impact on worker status across the board, but that wasn't the issue here. It was simply worker status for a very specific trade union right of getting this. My lord, I hear what you say about were they failing, can you reconcile those two findings with each other, because they're saying we won't make a finding, but it still complies with the margin of appreciation. In our submission, that's not what's said to have been done, and indeed that wouldn't have been sufficient for the court in these circumstances, because if the legitimate aim could not be made out to be proportionate, rather rationally related to the measure in question, the justification defence would fail. And that question simply wasn't considered.
Sorry, President, the timing point is still bugging me. This, let's go back 20 years. The Court of Appeal decides, rightly or wrongly, that foster carers don't work out. By that time, you have 1992 legislation in place, including Schedule A1, which was created in 1999. Was it at that point that Parliament should have said, well, we've got to amend the definition of worker in section 296 to include foster care?
No, my lord, we're saying it's at the time that they respond to this application. That's when all the evidence that was put before the court, as summarised in the witness statements here, should have, in our submission, carried out what's been referred shorthand as a best interest child determination in accordance with various international provisions which this first in the skeleton argument focuses.
So
now, that hadn't been done at any time.
I just want to understand this constitutionally. Government and Parliament are not the same thing. Though you would say that doesn't matter, they're both the state from the point of view of the convention. But just how would it play out?
Well,
The government would say, I know Parliament didn't consider this in 1992 because W hadn't been decided. But we, the government, in order to defend this case, will now carry out a major piece of policy work which will examine whether the denial of worker status for Article 11 purposes to foster carers is justified, and, assuming this is the conclusion, provide the reasons why we say that it is. Now, is that only required for litigation purposes, or are you saying that they should have done that immediately following W?
well, certainly by the time it gets to the stage of a challenge, that best interests analysis or assessment needs to be put before the court in order to satisfy the court that the material inquiry into the interests of the children is being carried out in order for the purported interference with Article to be justified.
It's proportionality. Because Article 11 incorporates a proportionality exercise when it's challenged. It's the burden lies with the state to establish that it's proportionate by whatever means and by whatever evidence.
What's been said below to the EAT will be said to the Court of Appeal today or tomorrow is that what the Secretary of State and failed to do here was to be able to discharge the burden of justification justification by reference to the interest of children as required, for example, by Article 3 of the UN RCR.
Yes. I mean, your point's a more general one. It happens to come up in the context of the children point. But any justification, including the other justification, based on having a uniform standard of definition of worker. I'm just, like my lord, I'm just trying to work out what this means in practice. I think really what you're saying is that's really not your problem. It has got to be justified to the court by evidence. That evidence could take the form of an evaluation that can be shown to have been done at the time that the legislation in question was passed, but it can equally be done retrospectively. Retrospectively is the wrong word, but
at a later point.
At a later point, and say, well, whether or not this was considered at the time of the legislation, it's justified now. But that may require, in a case of this sort, not just dusting down Hansard, it may require a major piece of research to be done by governments for the purpose of the litigation.
I can't rule that out. I'm anxious to start Article 14 before lunch, if I can, so I'm going to move on, please. We say that reliance on Article 11 read with Article 14 can succeed as a ground of challenge, even if the Article 11 argument fails on its own. And that's because we say the domestic definition of worker, in section 296 of TILCA, has got to be interpreted purposefully to give effect to rights not only under Article 11 alone, but in Article 11 read with Article 14. And that's because the Article 11 point focuses on the way that foster carers are treated differently, not being able to form trade unions which can be listed from those in analogous positions. So it's only necessary for the refusal to be listed to fall within the ambit of Article 11 for Article 14 to be engaged, and we say it clearly does fall within that ambit. So the first question to consider is the status of foster carers working other than under a contract and other status for the purpose of Article 14. And the EAT decided this point on two bases. Firstly, it said we are bound by Gillam in the Court of Appeal. And secondly, it said in any event, we would have found you had no other status. And our response to that is this court is now bound by Gillam in the Supreme Court. And secondly, the EAT were wrong in any event not to find that being a foster carer without a contract is another status. So if I could take you straight away to Gillam in the Supreme Court, please. And that is our quick answer to the whole other status argument. And
just paragraph 31, isn't it?
it's as simple as that. Page 2063. Is the start of Gillam. And 2116. Actually paragraph 32, but 31 is certainly as well. Paragraph 31 of Lady Hale's judgment deals with analogous situations. Paragraph 32 says an occupational classification is clearly capable of being a status within the meaning of Article 14. the very classification of the judge as a non-contractual officeholder takes her out of the whistleblowing protection enjoyed by employees and those who have contracted personally to execute work under 1B or 230. The constitutional position of a judge reinforces the view that this is indeed a recognisable status. And we could substitute the term foster carer and the context of section 296 of TULCA for that reasoning, and we would say an occupational classification is capable of being a status, and it's the classification of a worker as a non-contractual person providing services that takes the worker out of the trade union rights protection enjoyed by employees and those with contracts falling under section 296 of TULCA.
Can I just understand the reasoning 32? It's very abridged. Considering all the trouble taken by the Court of Appeal to grapple with all the case law on this, it's a slightly with one bound they were free type approach. She says an occupational classification is clearly capable of being a status. Doesn't say is, but is capable of being. So the next question would be, okay, that's capable of being, so why is it in this case? And we've just got two sentences. Indeed, which actually doesn't look like it's the next stage of the reasoning. It looks like it's simply a supportive sentence following the previous sentence, but still, it's the very classification as the job takes her out of the whistleblowing. I just don't understand. What is the actual reasoning process in that paragraph?
The court in Gillam had, of course, been taken through all of the law which the Court of Appeal had looked at below, and indeed which the EAT in our case, my Lord, had looked at below. And the reasoning is that an occupational classification is capable of being a status.
That's just said as if it's obviously true.
Well, it may well be, my Lord, that Lady Hale thought it was rather obvious.
Yes, and it may be that it is, but it's... anyway, keep going, yes.
And she says then that if you ask the question, why doesn't a judge have whistleblowing protection as those within Section 230 of the Employment Rights Act do, it's because of her classification as someone without a contract. That's what the indeed sentence is saying. You don't have the protection of the Employment Rights Act statutory rights because of your actual classification. And in terms of it being a recognisable status, is her simply backing up the question of status there. But were there, my Lord, a situation in which there was a judge employed with a contract in a certain position, it wouldn't mean that judges without contracts don't have an occupational classification. So we say that the fact that the reason...
But, sorry, what is the status? Is the status is judge, isn't it? The status is not person without a contract.
Well, it wasn't an issue that judges don't have contracts for this part of the argument, because they would never have got to this part of the argument unless they'd pursued it on the basis that they might lose on whether judges did have contracts. So
yes, well, I mean, at an earlier stage in Lady Hale's judgment, that's what she said. Yeah.
So the whole purpose of the whole classification here was not having a contract.
Is it, or the other state, the word other status is a status other than those listed in Article 14. And the status they must be referred to, because it's not referred to, it's just occupation. That's the status which is different to religion, politics, national security, origin, and so on.
Yeah.
Then within that, you've got two categories. You've got contractual and non-contractual. And she's simply saying, well, here the whistleblowing provision is distinguished between contractual and non-contractual, and therefore that's the unjustified differentiation.
Well,
I don't think it matters. I'm just trying to, in sort of conceptual terms, how it fits into Article 14. I think the status of occupation, because that's just not listed there.
I mean, we know that, you know, I'll come to
Well, I wonder,
status and how it's defined, but here,
if you look at the last sentence, it seems to be judge is a recognisable status.
well, my lord, I read that differently. I'd say the constitutional position of a judge reinforces that it can be recognised.
Well, this, what's the this?
Well, this, the occupational classification.
Non-contractual officer.
Yeah.
So the status is being an office holder, is that it?
No, the status is not having a contract.
Oh, I see. Well, sorry,
Whether
I
you're
mean
an
the two
office
is the
holder or
same
not
thing.
is
Well, all right, sorry,
immaterial.
quite right, but
That last sentence is a belts and braces argument, in my respectful submission, or a belts and braces piece of reasoning, because she's saying it reinforces the view that this is indeed
Yep.
a recognisable status. We say that's actually not necessary for the ratio.
no, fair enough. But that I quite accept. But sorry, I'm being very slow here. But your submission is that the status in 32 is being a non-contractual worker.
Yeah.
Well, actually, office holder. But that's because that was the facts of that particular case.
That was the facts of that case, but for reasons we don't need to spend time on now, it wasn't necessarily
Okay.
actually relevant.
Okay, thank you very much.
This great case is very unusual. It's a pure point of law because no defence of legitimate aim or justification was put forward. So either District Judge Gillam's status as a non-contractual office holder was a bar, or she won. And it's held not to be a bar, so she won. Because in most of the ECHR cases involving Article 14, it's all status is all bound up with defences of justification and legitimate aim and so on. And the other side in this case say the interference, if Article 11 is engaged, then the interference is justified, and Article 11 with Article 14, it's still justified.
I mean, here they did try and put a defence in, albeit there was no formal justification in place, and they ran an argument on analogous position as well. But certainly that was a big stumbling block to jump over. But we say the relevance of it here is occupational classification applies in just the same way to a foster carer working without a contract. Here, foster carers are deprived from the protection that it's enjoyed by those who fall within Section 296 in order to be listed. And it's because they don't have contracts that they're deprived of that. Other status is satisfied, and this will follow it in finding other status. Interestingly, I'm sorry.
Sorry, can I just raise a question which is bugging me? You may want to leave it to Lord Henry. I don't know how you divide it up. But Article 11 rights can be either an individual's rights or a trade union or prospective trade union. The evidence in this case says that some 500 foster carers have joined the GMB. Nobody is saying in this case, I think, that it is or should be illegal for foster carers to be a member of a trade The NUPFC, it's only just been formed, and it's special, is an organisation consisting wholly or mainly of foster care, us not working under a contract. But the GMB, for example, is a long recognised, long established and listed trade union. The overwhelming majority of whose members are not, are employees or individuals. So why is the classification of any individual who is a member of the NUPFC, why is the classification so important as it was in Gillam?
It is your point, my lord. Why don't you just go and join another trade union and be minority members?
Yeah.
Well, the short answer is Article 11 involves the right to join a trade union of your choice, and indeed here, foster carers have got specific needs and aims relevant to their particular profession, which is why they want to work collectively on improving their rights in due course. They don't want to do that as minority members of the trade union, and there's an issue as to if the non-contractual workers are seeking within the GMB or the IWGB to advance their aims collectively. Is it less certain that they can do so as doing that without contracts? That's in a nutshell, and I'm sure everybody will have something to make on that.
Right, well, that's a natural break, I think, unless there's something you're bursting to say before 1 o'clock. We'll sit again at 2 o'clock.